Good afternoon, everyone. I'm Michelle Suskauer, and on behalf of the Florida Bar, and it's about 106,000 members, I'd like to welcome you to our inaugural Criminal Justice Summit. We have an incredible gathering of presenters and attendees. If you could just look around and see, we have elected state attorneys, elected public defenders, judges, legislators, folks involved in different think tanks, practitioners, county courts, circuit court judges, appellate judges. We are so thrilled that you are all here. And we know that you have the knowledge and the will to tackle some of these very important issues, challenges facing Florida's criminal justice system, and to find meaningful ways to improve it. I've spent my entire career working within the criminal justice system, and now, as president of the Florida Bar, I've been given a larger voice and a platform with which to encourage meaningful, common sense criminal justice reform. So this is one of my top presidential priorities, and I'm thrilled to see you all here. So what we should expect over the next day and a half? No, I'm not going to lock the doors until we come up with consensus, although I'm tempted. But we're going to begin each day, today and tomorrow, with a general session where we're going to hear from at least one keynote speaker, and then we're going to split up into workshops. We're going to have 2 tracks, each with a moderator and a panel of experts. Here's just a couple of housekeeping items. The entire summit has been approved for Florida Bar CLE credit, with each session and workshop having a separate course number as indicated. So if you look here in your booklet, it will break down each session with your CLE course number and how much credit you have, so make sure that you take your booklet with you. All sessions are being videotaped for CLE, and the sessions and the featured speakers are going to be broadcasted and recorded on Facebook Live. If you are making any social media posts, please include the hashtag FLBarCJSummit. And for more information, you can see the Florida Bar has a CJ Summit spot on the website. Again, everything that I just spoke about is in the booklet. So let me just tell you briefly about our featured speakers. The first is Dr. Gipsy Escobar from Measures for Justice from Rochester, New York. Measures for Justice was founded to assess county by county our nation's criminal justice process from arrest to conviction. As the Director of Research and Analytics, Dr. Escobar deals with data. And of course, you know, without data, we have no way of knowing how to tell if our criminal justice system is working. We will also hear from Len Engel, who's the Director of Policy and Campaigns at the Crime and Justice Institute in Boston. His focus is on policy and legislative and regulatory reform across the country. Tomorrow, bright and early, our featured speaker is Nina Morrison, who is the senior staff attorney from the Innocence Project. Now, we don't want to waste a single second over these next 2 days. So at lunchtime, you're going to hear from the past president of the ABA, Hillary Bass, as well as Judge Bernice Donald of the Sixth Circuit U.S. Court of Appeals in Cincinnati, and Sarah Redfield, who is a professor from the University of New Hampshire, and they're going to talk about implicit bias. This is an interactive presentation, so be prepared to be involved. Now, the summit's workshops, as you can see from your booklet, will address sentencing reform, pretrial release, direct file of juveniles, specialty courts, juvenile sentencing, mental health, conviction integrity, and offender reentry. And we will be ending with an important general session led by State Senator Jeff Brandes and the chair of this summit, former Florida Bar President Hank Cox, where we will review what we've learned and discuss plans for future action. I do want to take a moment of personal privilege to acknowledge the hardships that were faced by many of our fellow Floridians in the wake of Hurricane Michael. Our prayers are certainly with them, and our thanks go out to the many Florida lawyers who have jumped in with offers to help, and they're continuing to help with issues ranging from landlord-tenant disputes to home repair contracts to just bringing food and water and clothing. I want to thank our summit's featured speakers and workshop leaders. You have invested so much time and energy and ideas and creativity to make this summit a success. To the Florida Bar Board of Governors, and we have some here, thank you for lending your approval and your support to this summit. I want to thank Josh Doyle. Thank you, Josh, our Executive Director of the Florida Bar. To Rick Cordemanch, our bar's Deputy General Counsel. Thank you so much for making this idea a reality. Without Rick, and so many of you who've been involved in the planning of this summit, you know that you've heard from him probably 100 times. And he invested hundreds of hours in making the speakers' lives a little easier, offering topics, and really dealing with every last detail to make this all work. Thank you so much from the bottom of my heart to the Criminal Justice Steering Committee, especially the committee chair, my good friend and colleague, Hank Cox. The members of this committee worked tirelessly. We had phone conferences for months, sometimes on a weekly basis, bi-monthly basis, sometimes a daily basis, to assemble this amazing summit. Their names are in the program, and I encourage you to thank them personally. And finally, a thank you to all of you for being here and showing a willingness to embrace change in Florida's criminal justice system. So now it's my pleasure and my honor to introduce our Chief Justice, Charles Canady. He took so much time to be here with us today. As you know, the Supreme Court is slightly busy. But I just want to tell you a little bit about his background. Of course, you can read it in your program. He received his BA from Haverford, his JD from Yale Law School. He practiced with Holland and Knight before he served 3 terms in the Florida House of Representatives from '93 to 2001. And he served 4 terms in the U.S. House of Representatives. He was also a member of the House Judiciary Committee, and from '95 to 2001, he was the chairman of the House Judiciary Subcommittee on the Constitution. When he left Congress, he was the general counsel to Governor Jeb Bush. Eventually, Governor Bush appointed him to the 2nd District Court of Appeal in 2002 and was appointed by Governor Charlie Crist to the Supreme Court in 2008. And this is his 2nd tour of duty as Chief Justice. He was Chief Justice initially in 2010 through 2012. We are so fortunate to have a chief who is such an incredible leader. We value our close relationship with the court. For those of you who probably don't know, we just had our long-range planning meeting, and Justice Canady was there throughout because he cares about the bar, he cares about the lawyers, about the practice, and of course, he's just an incredible leader of our judiciary. So without further ado, Chief Justice Canady.
Well, thank you for that very kind introduction. I am delighted to be here today, and I basically want to echo the thanks that have already been expressed by Michelle, but I want to thank her first and foremost for her leadership in initiating this summit and for all the work she has put into pulling this together and bringing the team of people together who have made the summit possible. I also want to especially thank Hank Cox for his leadership as chairman of the Summit Steering Committee. You know, Hank has done so much for our branch. I was thinking, you know, Hank, I don't think there's anyone I know who has done more for the Florida bar, with the one exception of Jack Harkness. So that's an inside joke. But we appreciate your service on the Constitutional Revision Commission and all the other things you have done for the Florida bar. I want to thank all of you who are here today as participants, the lawyers and judges and others who have come together to participate in the summit. And I know in the summit that you will be focusing on a variety of different issues. But underlying the discussion of all these issues, there's necessarily going to be an understanding of some first principles. Now, I think the understanding will vary from person to person about what those first principles are. First principles being, what is the purpose of the criminal justice system? What are the objectives? What is it about? What do we hope to accomplish through the criminal justice system? Now, I think it is almost universally understood that the purpose of the criminal justice system is multifaceted. You can't just say there's one thing we're trying to accomplish. There are many things that go into the mix. Most would agree, I believe. We look at punishment, retribution, deterrence, incapacitation, restitution, rehabilitation. Restitution and rehabilitation are sometimes thought of under a broader category of restoration. And all of these are important ideas that come into the mix. And different people, obviously, will emphasize different aspects of those multiple facets of what we're looking at when we look at the purpose of the criminal justice system. Another way of looking at it, we can look at the purpose of the criminal justice system as crime control. But you can never think of crime control without also thinking about due process. It's not just about controlling crime, it's in providing for public safety. It has to be done in a way that is consistent with due process for the accused and with the individual liberties of the accused. So all of those things go into the mix. And of course, people draw different lines and have different ideas about how all that fits together. But that has to be part of the backdrop of what will be in everyone's mind as they're confronting specific issues. And of course, even when we look at this dichotomy, or these two different aspects of public safety and due process, there's also the issue of fairness, just basic human fairness that goes beyond the requirements of due process. And I think most of us would agree that a purpose of the system is to be fair to everyone involved. And that's not a legal concept, that's just a kind of a principle that for policymakers looking at the system. Now, as I said, there are different views of which facets of the purpose of the criminal justice system should have priority. And those different views will necessarily affect the policy choices made by policymakers. But regardless, the first principles we all would have to understand are not self-implementing. There's a fundamental question, regardless of what you view as most important in what we attempt to accomplish in the criminal justice system, there's a fundamental question of what works. People can agree on first principles and have dramatically different ideas about particular policies because they may reach different judgments about what will work and what will actually accomplish what the desired goal is. And again, I know that's one of the things you're going to be considering here today, and I think that's very important. So this is a very important issue for the people of Florida. It's a very important issue for our judicial system. It's a very important issue for the members of our profession. And I am delighted that there will be a conversation here today, and I wish you tomorrow, and I wish you the very best for a productive discussion that will lead to a better criminal justice system for all the people of the state of Florida. And I wish you the very best. Thank you very much.
Thanks so much, Chief. We truly appreciate you kicking us off. So back, I guess about a year or so, maybe a year and a half ago, thinking about what some of my priorities would be, and having traveled around the state and meeting with so many of you, I tried to visit almost every state attorney, public defender's office, courthouse, talking about issues involving criminal justice. I thought this would really be interesting if we could get folks sitting down in the same room who maybe haven't done that before, and that we may be coming at these issues from different ways, but it seemed like the more I spoke to so many of you in this room, there was so much more in common that we had in getting to solutions than differences. Sometimes we don't think that way because we're at different tables in a courtroom, or we have a judge and a defense lawyer and a prosecutor and practitioners. We don't think that way, but actually there is so much more in common. And when I thought about potentially having this, there was really no one else I thought that could chair this summit, if I could get him to agree, than Hank Cox. Truly. And echoing what the chief said about Hank, not only has he led the Florida Bar and the Jacksonville Bar Association, the Supreme Court Commission and on innocence, and of course been an incredible member and a Supreme Court appointee of the CRC. He's done so much for the lawyers, for the judiciary, for the state of Florida. So when Hank Cox actually agreed to do this, I was thrilled because I knew that there was no one else who could bring that type of special credibility to this. Hank does not want an introduction. He said, make it really short and bullet point it. So I think I kind of glossed over, but of course I could go on, and he has worked tirelessly since and again, I didn't have to twist his arm to do this, where he worked on this every single day with Rick, with me, with others. No one has worked harder to put this together. So I'm thrilled, I'm honored to introduce my friend, Hank Cox.
Someone asked why I would consider agreeing to do this sometime back, and the answer is simple. My life constitutes a lifetime search for CLE credit. Chief Justice Canady, I appreciate what you said, and I appreciate the confidence of the court in being able to serve on the CRC, and it was especially a privilege to be on the short end of 106, 34-3 votes. So, and I will tell you, y'all think that's funny, don't you? I know, Chief Justice Canady, what you're thinking. I told Justice Polston and I told Justice Labarga I'd like to do it again in 20 years, but I'm going to pass. So I want to applaud Michelle for this ambitious adventure. She used the word reform. Reform is a word I think that scares people off sometimes because it might suggest that some people want to get together and change how I do things, and I've already determined that I do them the right way. I told her that if this were going to be unbalanced in terms of prosecution, defense, or judiciary, that I was not interested, that if it was going to be an opportunity to showcase one office's policies or strategies that were better than the next office's, I was not interested. I agreed only so long as this mission was to share the ideas, policies, strategies, and provide a forum for people to learn how other people do things and make their own independent decision whether or not there's room for improvement or is not within the justice system in this state. I want to thank, as Michelle did, the steering committee. I want to thank the panelists. I want to thank the moderators. And that process itself was a reminder of the sensitivity that people in the criminal justice system have to working in the same room with people who live on the other side of the counsel table in courtrooms. Many people have their own agendas. The purpose of this is to not to surrender your agenda, but to listen to what other people have to say about everything and strike a balance. And perhaps in the area of human affairs, things can be improved. As Michelle said, mechanically the process is outlined in the program. CLE credit, if you look at the bottom of each panel, there is a different course number. You have to remember that. You can't use one course number and get credit for the whole thing. You have to enter each because the panel subject matter is different, and you may be in a different room and not hear one of the others and hear it. There are two breakout rooms. There's this one, and we'll start that at 3:30. There's another one which is downstairs, and I say this room, it's right around the door to the room contiguous on the other side of that door. And the other is the Duval room, which is one floor down. Go down the escalator, go 180 degrees around the semicircle, and you find the Duval room. And then there will be a reception in this room immediately afterwards for everyone. Tomorrow, breakfast will be served at 7:30 a.m. We'll begin at 8 a.m. in this room. And after the breakouts in the morning, there will be lunch served for everyone in this room. Now, Dr. Escobar has come here from Rochester, New York. It's Measures for Justice. It was founded 7 years ago as an effort to analyze actual data and to assess the criminal justice system from start to finish and compare the criminal justice systems on a county-by-county basis and throughout the United States. Her background is in your program. She is professor in the Loyola University of Chicago, Department of Criminal Justice. She has a doctorate from John Jay College of Criminal Justice in New York City, and it is a privilege to welcome you to Florida, Dr. Escobar.
Thank you so much for having me. I'm really honored and so glad to be here. Sorry. Because we've been doing so much work in Florida, and I just love to see the faces of the people who are behind the numbers, right? As Michelle and Hag mentioned, Measures for Justice is a nonprofit, nonpartisan organization that is trying to measure the performance of local criminal justice systems across the United States, one county at a time. With over 3,100 counties in the U.S., you can imagine it is not an easy task, but we're definitely up to the challenge. So today, what I would like to do is talk to you a little bit about what we are doing, how we're doing it, and why. And then I will also want to talk a little about the work we're doing here in Florida, actually next door in the 6th Judicial Circuit, and tell you a little bit about how we are supporting the implementation of SB 1392 with a pilot in that county that we hope we will be able to, the knowledge that we acquire there will be able to be shared in other jurisdictions. So thank you, Michelle. Thank you, Hank. Thank you, Rick. I see my friend Deb Broski there, so I'm going to give you a wink. Thank you, Bill Servone, who for such a long time have been such a supporter and giving us so many good, constructive criticisms. We wouldn't really be here without you. Thank you so much. So with that, let me start by trying to click this. Oh, I think, no, is it on? Off? Maybe I'm too far. Okay. Oh, I think it's moving in the computer, but not in the screen. So I'll start telling you what the first slide says. So what Measures for Justice basically does is we collect record level data from criminal justice agencies across the country. A lot of the data that we started collecting started with the data that is centralized in the administrative offices of the courts. Thank you. We did that with OSCA here in Florida. So we do that record level collection where it says that we collect data on every single person that goes through the system. That's really hyperbolic because not every single person that is processed through the entire criminal justice system necessarily makes it to the centralized data systems that exist around the country. But we take that data, we analyze it and run some procedures on it to create some measures, some indicators of what we call the health of local criminal justice. And the Chief Justice was earlier talking about the goals of the criminal justice system. So we have developed a system of measurement that gets at what we think are three of the major goals of the system, which are public safety, fair process, like the justice was mentioning, and we also think fiscal responsibility. The fact that the taxpayers are paying for the work that criminal justice system practitioners do, and that we should be responsible with that taxpayer money. Then we take those measures and what the platform really does, and I'll show it to you in a little bit, is allow you to compare how counties are doing within the same states and actually across states as well. And this is not to shame and blame. This is really to get at what Hank was saying, is let's see what's working where, and let's see if we can start a conversation, whether we can start a peer network where areas that might be performing better in some parts of the process could help other jurisdictions that may be struggling. So first thing I will say is as soon as you say performance, as soon as you say measurement, like reform, people get scared. But the goal here is not to shame. The goal here is to start a conversation. So in fact, our measures, we've worked very hard, like we worked for the first 4 years, developing them conceptually to make them neutral as possible, to select some measures that were relevant to the process from beginning to end. And this is an iterative process. This is a living, kind of like document. It will change as we get more feedback from more of you. And we did this work with groups of national experts, both in academia and research, but also from people like you, lawyers, attorneys who worked in prosecutors' offices, public defenders' offices, judges, sheriffs, law enforcement, people from departments of corrections, et cetera, where we workshop the measures and integrated that feedback that they were giving us. Bill Cervona, I was saying before, was instrumental in giving us feedback when we were in that early process. Judge Leifman down in Miami was also very involved in the process. Carlos Martinez, also from Miami, and Carrie Hockton from Palm Beach were also very, very instrumental in the process, as Sheriff Atkinson from Walton County was as well. So the idea of the system, and we're not by any means done yet. We're still in the process of trying to create that funnel from beginning to end, from arrest to post-conviction. The goal is to get to that level of measurement where we can measure what's going on in each jurisdiction from arrest to post-conviction throughout the whole stages of the system. So looking at the early stages of the criminal incident, the arrest, and the work of law enforcement, looking at the pretrial process, including arraignment, investigations, and court processes, trial and sentencing, and post-trial, looking at things such as jail usage, recidivism, and defendant impact or collateral consequences that oftentimes people, particularly people of low income, can experience after having an encounter with the criminal justice system. The process, and I'm not going to bore you with methodology. I know what audience I'm talking to. And this is boring even for researchers anyway, so I'll go through it quickly. So we developed the measures, like I said before, with groups of experts. We workshop them with tons of practitioners in several states. We then collected the data, and what we currently have in our data portal, which is publicly available, any of you can go on it at any time and check it out. We cleaned the data that is in the portal right now is coming mostly from the courts, but we're right now in the process of integrating data from prosecutors' offices, public defenders, sheriffs, DOCs, law enforcement, trying to match cases across agencies, which is a humongous challenge because for whatever reason across the country, this is not just a Florida problem, but across the country, criminal justice agencies tend to use different ways of identifying cases, and they don't necessarily speak to each other, so that leads researchers to use algorithms to figure out which cases and which defendants are the same across agencies. So we're working on that. So we clean and code the data. I have a staff right now, about 18 researchers who are helping with this process. We've spent like I said before, like about 4 years figuring out a standard operating procedure that will allow us to compare apples to apples. There is many challenges to this, to standardization across states and within states. So one of the big challenges was standardizing to a common way of defining charges across statutory laws. That's still, we're still adding more states to that. But also standardizing the use of terminology within states, right? Not all practitioners within the same state use the same words to refer to the same practices. So a dismissal or a deferred prosecution or a pretrial diversion may mean different things depending on who you're talking to and where. So we've done a lot of work to identify patterns in the use of terminology as well so that we can standardize. That goes through a very strict auditing process. We have a process where we do internal audits first. Then once we are relatively happy with those internal audits, we send out to an external auditor who is an expert on criminal justice process, criminal justice data from that state. We have a conversation with that expert. Once that passes that audit, it goes to the last and foremost stage of the quality control process, which is the stakeholders. It goes back to the practitioners, people like yourselves, who will tell us, all right, this pattern here doesn't look right. This is funky here. Maybe you should suppress it. In Florida, we ended up suppressing one measure, pretrial diversion measure, because when we showed it to the practitioners, they told us it's way too low to be true. And that led us to realize that what was happening was that the court clerks were replacing the pretrial diversion decision with its outcome. So instead of showing up as a pretrial diversion, it was showing as a dismissal if it was a successful diversion, or as a guilty plea if it wasn't. So it was not reliable data. So we ended up dropping that measure. Once it goes through that level of quality control, we publish to the data portal. Hopefully we do some media, and people come to check it out. So last year we published 6 states, including Florida. Like I said before, all with data from the Administrative Office of the Courts. In the Florida case was OSCA. And our goal is to get to 20 states by 2020. What you see in the map on the left here, I guess my left, your right, is actually 22 states. So we are hoping that we'll be over-delivering, at which point we think this is going to create a tipping point and a demand for this kind of data that will help us do this work in the harder to get places like Mississippi or Louisiana, where there might not be centralized data, where a lot of core businesses is still being conducted on paper and not necessarily in more modern ways, like in Florida, in computer systems. So, is it okay if I step down here so I can manipulate the thing? Yeah, should I bring this thing with me, or how? I'll scream. How about that? All right. Whoop. That should do it. Let's see. All right. It's going to be a little tight in there, but anyway. So if you go to measuresforjustice.org, you'll be able to access our data portal. So I'm going to hopefully click here. There we go. You'll see where you see those 6 states for which we have data. Oops. The availability and quality of data varies greatly across states. The state for which we were able to populate the most measures was Wisconsin, where we were able to populate 23 measures. The fewest measures we obtained were in Utah, where we only populated 5. And in Florida, we were able to populate 18 measures. Now, like I said before, we developed 32 metrics So that means for Florida, we have a little bit more than half of the measures that we would like to populate. And this is what was one of the things that Representative Chris Prowls looked at when he was thinking about SB 1392. And he saw a data gap, and he thought that Florida could do a lot better, and that he would like to see all 32 measures populated. So we go to, and we are revamping and streamlining this so there's not that many clicks. You see here the measures that are available in Florida. I'm not gonna waste too much time on that. Let me just go to this cases not prosecuted, which is really about prosecutorial screening practices. Not now. It'll give you a tour. If you'll see here, kind of like how we define the measure, we tried our best to keep the definitions neutral. And this might be a measure where we might want to reconsider the name of it. One of the things that we heard a lot from prosecutors is that people are going to say, oh, so people are going to say we're not doing our job because we're not prosecuting cases. But what this measure really is about case screening and the prosecutor's job as the checks and balances for police work, right? I think most of you will agree with me that filing every single charge is not justice, right? That convicting every single charge that gets filed is not justice. So that the idea of this is to show that kind of discretion. So here you see the map, and your state better than me, so I'm gonna go to the bar graph, which I like better, but the computer doesn't really like me. Oh, here we go. Oh, here we go. So you see that there is a level of variation across the state. Each bar is a county, represents a county. The bar, which goes up to about 36%, shows you. If I click on it, it should pin it. There we go. So we can look kind of like at the highest and lowest county, but you can also search here for specific counties. I'm gonna click on Palm Beach. I'm gonna click on Hillsborough because we're here. Pasco and Pinellas, because those are our pilot counties. And if anybody wants to shout out a county, I'll be happy to oblige. Marion? Any other one? Sarasota? Oops. Sorry, I became a Mac person a long time ago, and now PCs. I heard another one. Duval. Okay. All right. I think I can only choose 12 at a time, so we'll leave it at that. So once you select your county, Duval, we don't have data because there were, by the time when we did the data collection back in 2014, Duval, Nassau, Flagler, Osceola, and Seminole were not reporting data up to OSCA. So we are missing a lot of information from those counties. We did collect the data later from the court clerks, but the court clerks did not have the referrals and the prosecutorial screening decision. So in Duval, we're missing that information. But it'll tell you that right there. I'm gonna open this up a little bit here. Sorry. And you'll see how the numbers kind of are behaving in general. The other thing that I will say is that to be able to standardize across jurisdictions, we have to come up with our own case definition because different jurisdictions have different practices. So we define a case as all the charges either filed or referred in the case of the declinations against the same defendant on the same date. Because that was to control for jurisdictions where multiple charges that are associated to the same incident against the same defendant may be filed under separate docket numbers, and jurisdictions where all those charges will be filed under the same docket number. So for us to be able to compare apples to apples, we had to create a standard definition of case. So that, that's why if the numbers here, which by the way are for 5 years, 2009 through 2013, if the numbers here don't exactly match what you know from your office, is because maybe the case definition is slightly different. So you can see here the numbers. We also provide some information on missing values. There you go. Here. And in order to kind of like provide the full picture, we provide some companion measures to the cases not prosecuted, where we also look at the case dismissal rate and the conviction rate. I'm going to select Palm Beach here, just for the sake of argument. I always click the wrong thing. So in Palm Beach, you see that about a third of cases that come through the door of the state attorney's office are declined for prosecution, right? A media person with bad intentions may take this and turn it against the prosecutor and say, hey, you're not doing your job. How come you're not prosecuting all those cases? But then the prosecutor, the state attorney, can say, well, but look at it. Because I'm declining all these weak cases, I'm only keeping those, or the majority of the ones I'm keeping are cases that I know I'm going to be convicting, right? And look at my dismissal rate. It's only about 15%. I'm convicting about 70% of the cases that I file, right? Which is a ratio of, cases from referral to disposition that is what arguably you will desire to see. Right? More declination, like more screening in the front end, and then just leaving kind of like the strongest cases for court processing. So this kind of gives you an idea in general of what the data portal offers. I'm not going to spend too much time here because I do want to get to the what we're doing with SB 1392, but what I will want to do is show you, if I can figure it out, show you a quick video about how criminal justice practitioners around the country are using the data. Oh, I don't think there is, you're not going to hear it. Is there a way to? Is it rolling here? Maybe it's not connected to the audio.
Go ahead, try to play it there and see.
Okay. No, I don't think it's working. Anyway, I'll just tell you the story quickly. If you want, you can check it out. It's on our website as well. Now I'm going to move back there, so I'm going to. So some of their data has already been used by a prosecutor in Wisconsin, where he saw that there were a high percentage of people who were incarcerated pre-trial for failure to pay bail. Over 45% of them were being held in jail because they could not afford bail of less than $500. So he said, the majority were, bails around $130, $300, and $500, which is what his county's bail schedule has. So he used that data point from our data portal in the way that we wish people used it, which is just to start the conversation and start asking more questions about it. What was behind that pattern? So what he realized was he dig deeper into the information of the data of his own office, and he saw that the majority of people in that group were indigent defendants. The majority of them had been arrested for a low-level offense. The majority of them were arrested on weekends and holidays, and the majority of them were then released during the weekday on recognizance, at the bail hearing. So what he found out was that judges who were holding arraignments over the weekend and holidays, usually via video conference, were requiring the presence of a prosecutor to make the decision to release, right? Because, some risk-avoiding behavior there. So what the prosecutor did is he waived the presence of his attorneys to these hearings so that if the judge decided, that judge will decide later on during the weekday when a district attorney will be present at the hearing, if the judge considered that the person should be released, they could be released right away instead of spending, 3, 4, 5 days in jail, costing about $45,000 a year to a small county in Wisconsin, rural county in Wisconsin, and with all the collateral consequences that could have for the defendant. The public defender of Philadelphia noticed that the pretrial release violation rates in Philadelphia were quite high. She went in, digging further into the data, and she presented that piece of information to her social services team. And from then on, her social services team started offering more services and having more contact with the public defender clients, and the pretrial violation rates went down dramatically. And a prosecutor in Utah who had been in office since 2007 and never, ever, ever gotten a dime from his county board to hire new resources. He showed the data from Measures for Justice to his county board. He said, it looks like we're doing well, but if we're going to continue doing well, I'm going to need more resources, including a data person. The county board appropriated money for 4 hires for him, including a data person, which was, never seen before in his county. So there is a lot of use to this data. I know data and measurement are scary, but if used appropriately, they can provide a lot of opportunities to continue doing good things and to take a look into the things that might not be working well. I'm going to go give a shout out here to Melissa Nelson and Andrew Warren, who have been working with Florida International University to create a system of prosecutor performance indicators within office. This wouldn't be public facing, but it's for office use. And they have been doing a tremendous work. They've opened their offices to these extremely qualified researchers to help them with this. So, a little bit of open-mindedness, a little bit of, not being so afraid of data could go a long way. So, like I said before, Representative Sprouse saw the data portal, saw the data gap. Only 18 out of the 32 measures in Florida were available. In Florida, according to the Vera Institute, in 2015, at the end of the year, there were about 50,000 people in jail at about $64 a day on average. That's $1.2 billion a year. That's a lot of money, right? Yet, from the data that we were able to work with, we didn't know anything about bail and pretrial release. We didn't know anything about bail amounts, failure to pay bail, pretrial release violations. None of this information was available in the OSCA data. As I said before, there were poor record-keeping practices regarding pretrial diversion and deferred prosecution, which didn't allow us to create that metric. There's no information on the representation continuum of care or horizontal representation. We don't know anything about, all we know from the data is the attorney type, and that it will be the last attorney of record, but we don't know when the attorney was assigned. We don't know if there were withdrawals. We don't know what kinds of motions they were filing. And there were several weaknesses in the sentencing data. If you go and play with the data portal, the sentencing data for a lot of counties will have high missing values, and we were unable to create a measure for several counties. And to top it, the race and ethnicity information in the state is extremely poor. The state with the largest proportion of Latinos in the population is not really tracking data on how Latino defendants are doing. And I know this is a hot button item for a lot of people. But what I will say is that the practices that we saw reflected in the data are so that Latinos were being lumped with whites. So it makes it very hard to tease out what's happening to that population, right? We did create measures of the racial disparity where we were looking, comparing white defendants versus defendants of color. Whenever we see that racial disparity there, it's mostly reflecting African Americans because we don't, the Latino population is being modeled up and confounded with the white population. So that data gap analysis is what inspired the House Judiciary Committee, Representative Sprouse, and later Senator Brandis, who will be here tomorrow, to push for this SB 1392 bill. It got a lot of attention. and still getting a lot of attention. You see the headlines there, from Wired, Florida could start a criminal justice data revolution. Daily News in New York, we're located in New York State, upstate New York, crunching data to deliver justice, maybe one day in New York. It's not even happening in New York yet. So a lot of eyes are on Florida right now because of this criminal justice transparency bill. So the bill did something weird that I don't think, I'm learning about the legislative process here in Florida, but it had never done something like this where it wrote into the bill a pilot project for implementation, and without naming names, it pretty much designated Measures for Justice as the group to conduct the pilot. So the letter of the law says that a national, nonpartisan, nonprofit entity which provides data and measurement for county-level criminal justice systems were to enter into an MOU with the 6th Judicial Circuit to improve criminal justice data transparency, ensure data submitted under Section 900.05 of Florida statutes is accurate, valid, reliable, and structured, embed a data fellow within one of the agencies to assist in compiling and reporting data pursuant to the section in compliance with rules established by FDLE. We now have those 2 data fellows. One is embedded in Pinellas County, Ariel Fonticiela over there, and the other one is embedded, and also a project manager who's right now helping with PASCO, Sam Harden, both been described to me as unicorns because they're both attorneys with a criminal law background. They in criminal defense who turned coders, right? They took some classes on coding. They're expert coders now. They understand data better than anybody, and now they're helping Pasco and Pinellas to meet the implementation of the rule. Our commitment was to support. To provide a 2-year support and technical assistance to the 2 counties. I can proudly announce today that we secured funding for the 2-year pilot. The Arnold Foundation kindly has given us the money to be able to do this for 2 years as the Koch, I'm going to say institute. I think the Koch Institute, right? Yeah, thank you, Deb. Not the foundation, did as well. Why data fellows? Why are we providing this support? They're an additional fully dedicated resource that is aimed at easing the transition to the new reporting requirements. They can serve as a bridge between agencies to streamline reporting and avoid duplication of work. And both Ariel and Sam are expert communicators. They have been amazing at working the relationships in the two counties. They can help strengthen data culture within the county. And what we're really hoping, though the aid might be seen as limited because it's only for one judicial circuit, I'll tell you right now, it costs more than $1 million to have the aid for 2 years. Even though it's limited, what we're really hoping is that the pilot will serve as a vehicle to help all jurisdictions in the state. So a lot of the work that Sam and Ariel will be doing in the 6th Judicial Circuit is something that we hope we will be able to make public for everybody. We're going to make whatever code doesn't involve any confidential information from cases. We'll make that code available and open source to people. One of our deliverables will be a standard operating procedure that all jurisdictions can use. We'll also be offering training to anybody who wants to learn how we're doing it in Pasco and Pinellas so that they can replicate processes there as well. So the intense technical assistance is focused just on the 6th Judicial Circuit. We are really hoping that this can explode to the rest of the county. So what are they doing? I'm just going to go quickly here. They are reviewing and validating historical data. Each county very judiciously did a self-assessment of their own data gap. And so Sam and Ariel have just finished analyzing that self-assessment and identifying the needs to address in the areas of technology, workflow, and local law government data. They're identifying short-term, no-cost solutions to comply with the deadlines. What we're hoping that we can do is that at least during the first year of implementation, we can do this without having to pay the vendors to upgrade the case management systems. So it's, trying to be creative there. They're working with the county to ensure there is a sustainable environment so that this can be maintained after we leave. The idea is to create institutional capacity as well, not to be in and out and then leave nothing behind. Working with the CMS vendors to identify upgrades. Working to comply with the FDLE's data specifications, and working to develop that SOP, standard operating procedure, that we'll be sharing with the rest of the state, as well as training personnel. The process to date, we've established relationships, we mapped the data structure, data flows, and personnel workflows. We're working with each agency data team to address gaps and data structure. We've analyzed the self-assessment and created a data extraction plan. We're creating the scaffolding for a data pipeline that will include linking records across agencies. We're using the pilot as a vehicle for other jurisdictions to provide feedback. So one of the things that we want to do at the end of the year is to have a report that we can send back to the legislature to strengthen the bill. So we will be doing a lot of the work in the pilot, but then we will be moving up the information through the associations so that everybody else can get input to the legislature for the next session. And recommending other amendments to strengthen the legislation. To conclude, I'll say that one of the complaints that we often get is that the data that criminal justice agencies are collecting is not meant to be used for research, that the data has tons of problems and limitations. But even with imperfect data, we can start putting into action if we put meanings and measures behind it to start that conversation across the criminal justice system. We can fix what we can't see, right? Oftentimes, it's become almost trite in the media to say that the criminal justice system in the United States needs reform. Okay, but how? We won't know how the system needs to be reformed unless we can see what's happening using data. Data can tell us what works and when and where systems may go wrong, unbeknownst to those working within the system. Like the few examples I gave before give you a little bit of a sample of practitioners who had no idea there were certain patterns that were going relatively wrong within their jurisdictions because the data had not been used other than for case tracking. So again, using the data can tell you, can show you things you were not aware of, and could really help your offices. Data can tell us where there may be appropriate opportunities to make the system more efficient, effective, and fair. And making the data publicly available can be the catalyst that enables communities to come together around needed evidence-based reforms. So once again here, and I think the Chief Justice, Michelle and Hank mentioned this, we need evidence-based policies, right? We need to be able to support policies with data and research. So I'll leave it at that. I don't know if we have time, but I'd be happy to answer any questions.
We have a little less than 10 minutes for questions. So.
Yes.
One question on the data that you showed for Florida on your website, the dates, the most recent dates, it looked like it was 2013.
Correct.
Is that the most recent information you received, or why is it 5 years?
Because it took us a long time to actually figure out the process. But the goal right now is to refresh the data at least every other year. So next year, we're going to be publishing the next iteration of measurement that will cover the period 2011 to 2015. We're doing overlapping periods, kind of like to address concerns about what's called history biases. So we're going to do 2-year removed overlapping study periods. And hopefully by 2020, we'll be in a place where we can refresh yearly. Anybody else? Criticisms? I have a very thick skin.
Thank you very much.
Thank you.